Thank you, Senator Tabitha. Senator Edwin Sifuna.
Thank you, Honorable Chair. First of all, allow me to commend members of this committee. As you know, the committee is chaired by a former classmate of mine, Honorable Speaker. And it is such bold decisions that make me proud of being a member of this House, that we can look at legislation objectively and say we have issues with this proposed legislation and that we cannot support it. In fact, some of us have taken a position on previous legislation that has been sponsored to this House or originated from the National Assembly, that if a bill is unconstitutional, you should not even entertain the thought of subjecting it to a third reading where you then introduce amendments, because our position in the minority is that you cannot introduce any amendments to breathe life into an unconstitutional bill, and that an unconstitutional bill should be dealt with forthright from the beginning as an unconstitutional bill. So, Honorable Speaker, I see the members of this committee here are people that I would take their position very seriously. I see that Senator Catherine Muma is a member here, Senator Veronica Maina, and of course Andrew Omtata Okoiti, people whose advice on the constitutionality or otherwise of any piece of legislation I take very seriously. Honorable Speaker, there are 3 or 4 examples that I wanted to give, and I saw that the chair of the committee himself ran us through as a House some of those unconstitutional provisions, and this is what led to the conclusion by the committee that we as a House cannot abide by some of these proposals. But I want to challenge the committee that after we reject this bill, I think one of the problems we allow ourselves to get into, Honorable Speaker, is to allow such bills to originate from the National Assembly. How do they beat us to originating such legislation? In the historical relationship between these two houses, the Senate has always complained of being the one that is being sidelined, the one that is being undermined at every turn. Then if we are going to have legislation to repair that relationship, we as the wearer of the shoe, honestly, Honorable Chair, should be the ones originating the legislation that we believe will cure this particular problem. And I know that a bill originating from this House to cure this relationship would be far much purer, because we are motivated in this House by the desire to see these constitutional institutions working and nothing else. I would trust this House to prescribe the medicine to this problem than any other place. So, Honorable Chair, even as we argue for the rejection of this bill, even as we reject this bill, I would very much challenge the members of the JLAC committee to, with haste, put out our own version of a bill to guide the relationships between these two houses. It's unfortunate that the leader of majority is not in the House with us today. Honorable Cheruyot is somebody who has walked this journey of the relationship of these two houses, including the interpretation of Article 110, the matter that is before the Supreme Court, and what needs to be done. And he has cautioned us that during debate of this matter, we should not make it as if the entire National Assembly is in fact at odds with the Senate. And the best example, Honorable Speaker, was during the debate on the Division of Revenue Bill that was passed by this House, where it was clear that, in fact, it is only a small section of members of the National Assembly who think that everything should be perceived through the lenses of conflict between these two houses. But a vast majority of the members of the National Assembly, and you will see this demonstrated, Honorable Speaker, when we go to mediation over the Division of Revenue Bill, there are people who actually believe in devolution and making sure that these institutions of devolution, including the Senate, work. Honorable Speaker, as you yourself or the chair of the committee rightfully pointed out, if you look at a provision such as the one that you referred to, or the chair referred to, relating to when a dispute can be said to have arisen or when it needs to be dealt with in accordance to Article 110(3). Honorable Speaker, Section 6 of that bill wants to rewrite Article 110(3) of the Constitution, because the wording of Article 110.3, and I have my copy of the Constitution here, presupposes that any dispute will be dealt with prior to any of the bills being introduced in any or either of the houses. But what Section 6 of the bill proposes to do is to rewrite that to mean a bill can actually go before the House and undergo the first reading, but then to move the time frame at which point we can raise objection to that bill or declare a dispute under Article 110.3 to just before the second reading of the bill. Because, Mr. Speaker, the resolution of those questions needs to happen jointly and in the language of the Constitution under Article 110.3 before either House considers a bill. Now, I don't know what the National Assembly defines consideration as, or when consideration of a bill begins. But surely, Honorable Speaker, by the time you are introducing a bill at the first reading, that is consideration of the bill, and all matters must have been resolved before that is done. Secondly, Honorable Speaker, you yourself have made reference, and honorable colleagues who have spoken before me, to the provisions of Section 19.6 of the bill on the question of public participation. Again, Honorable Speaker, under Article 118 of the Constitution on public access and participation, there is a requirement, Honorable Speaker, that every single piece of legislation that is being considered by either House go through public participation. In fact, my argument, Honorable Speaker, is it doesn't matter where this bill originates. If a bill is introduced into this House from the National Assembly, my thinking is that as far as the Senate is concerned, as far as the Senate as a legislative body is concerned, that is the first time we are interacting with that bill, and therefore a key component of our consideration and passage of that bill is public participation, so that we as a House can never have an excuse to abdicate that responsibility and go through a bill or any proposal before this House without subjecting it to the constitutional requirement of public participation. When Senator Maanzo was speaking, he made reference to the housing bill that was introduced from the National Assembly as well. And, Honorable Speaker, the Hansard will bear me witness that we in the minority...
Senator Sifuna, just hold. Senator Karen, the chair earlier on cautioned you against what you're doing. You're out of order. Proceed, Senator Sifuna.
Honorable Speaker, I was saying that if you look at the Hansard, we in the minority, during debate on the housing bill, were of the opinion that, in fact, because housing is a devolved function, because it is a legislative mandate of this House to deal with questions of housing, we needed to subject that bill to our own independent public participation to find out the views of Kenyans, Honorable Speaker. And the word of caution, of course, results from the fact that previously we have seen very shambolic so-called public participations before the National Assembly. And in fact, Mr. Speaker, one of our biggest shame as a nation was where public participation is conducted on a bill before the National Assembly, specifically the Finance Bill of 2023. 99% of the people appear before the committee, relevant committee, and oppose the provisions of that bill. And in the end, all of those proposals, all of those suggestions from ordinary Kenyans, from the Kenya Association of Manufacturers, from civil society, from all those quarters are ignored, and the bill is passed anyway. And we hear leaders in the National Assembly pronounce themselves at funerals and other public events that the bill will pass, not even a comma will be amended. I am happy, Honorable Speaker, that given the noise that we made, especially as members of the opposition or the minority in this House, I am seeing stories in the newspaper that members of the National Assembly now are insisting on being taken through provisions of bills before they vote. I think that is progress, although we have set ourselves an extremely low bar where a member of parliament can admit to passing a bill without reading it. But now that we are reading, I think when we go to the election in 2027, we might have a different story. So public participation, and the courts have spoken on this matter, Honorable Speaker, that it cannot be a cosmetic exercise just to check boxes and say we have complied with the law on public participation. it has to be substantial that the views of the people must reflect in the final document. We as a House and even the National Assembly can never avail ourselves of power to do away with the views of the people on any particular legislation. Honorable Speaker, there is also a very interesting provision under Section 20, subsection 5 and subsection 6 of the bill. And Honorable Speaker, allow me to just read this one out verbatim, because I believe this is meant to intimidate professional staff of the Senate and the National Assembly from actually advising this House to go and avail itself of the options of going to court whenever there is a matter that we believe is not right. And Honorable Speaker, we have enough matters in court to prove that that is also an option that is available for us as a House, because although we are the lawmakers in the land, injustice can also be visited on us, and especially on the Senate as a House. So where, Mr. Speaker, you have a provision of a bill saying under Section 20, subsection 5, that if a court is satisfied that a House of Parliament in an attempt to resolve a dispute has not exhausted all the mechanisms of alternative dispute resolution as contemplated under this section and refers the dispute back for the reason that the House of Parliament has not complied with this section, the expenditure incurred by that House of Parliament in approaching the court shall be regarded as wasteful expenditure. Then it goes on to say under subsection 6 that the cost in respect of wasteful expenditure under subsection 5 shall, in accordance with a prescribed procedure, be recovered without delay from a public or state officer, including a holder of a political office, who caused the House of Parliament not to comply with the requirements of this section. Honorable Speaker, you and I have the privilege of sitting on the Senate Business Committee. You have seen numerous examples of attempts to resolve matters internally that I have failed. Because of various issues, Honorable Speaker, and I can see the Senator Mutinda knows exactly what I'm talking about. It is possible for us to fail to agree internally. And even when attempts are made, there are people who sabotage attempts to resolve matters between the two houses, amicably. So if an officer of the Senate advises the Senate that at the stage at which we are, the only place that we can find a resolution is in the courts, and then they say, oh, by the way, it is Sifuna, as a holder of a political office, as elected member of the SBC, who refused mediation and who said or insisted that we must go to court. And they recover the money from me, Honorable Speaker. This is meant to intimidate people from availing themselves of the option and exercise of a right to approach the courts for dispute resolution. And therefore, on the basis of that, Honorable Speaker, I will be objecting. In fact, today, we received very good news as leaders of political parties. And I am sure even the Secretary Generals of all the other political parties are happy that the High Court has agreed with us that the National Assembly cannot just unilaterally, through a supplementary budget, go and remove all the money that has been allocated to the political parties fund. I am very happy with Justice Muita. He has said that money, once appropriated by the National Assembly, cannot be again reduced through an appropriation act, as happened with the first appropriation act or supplementary budget of September of 2023, that reduced the political parties fund by almost 800 million shillings, Honorable Speaker, when we only had 1.6 billion shillings on that fund. So I am hoping that going forward, I have taken the liberty of sharing that decision with members of the National Assembly, at least those from my party who I know sit on the Justice and Legal Affairs Committee and on the Budget Committee of the National Assembly. They need to take note of what the court has said. One of the most frustrating things, Honorable Speaker, is that at least for us at ODM and with the political parties fund, we have more than enough court orders, Honorable Speaker. We have a court order that I awarded as 6 billion shillings a few years back. It is now 10 billion shillings. Nobody is bothered about honoring that court order. So when we hear people pontificate out there that they are a rule of law government, and yet they have active court orders that they are ignoring, we know these are hypocrites. So on this particular one, Honorable Speaker, I want to support the committee that in fact we cannot have a situation where our members of the Secretariat are threatened with sanction for advising this House to go to court when there is obvious injustice that has been meted on this particular House. Lastly, Honorable Speaker, and this is a matter that Honorable Gerard Gay, the Senator for Nandi, spoke about, on this question of joint sittings. And this is why I have always pleaded with my colleagues in this House that when matters such as this come before us, we must show a united front as senators. When you see a member of the National Assembly disparaging the entire Senate, it includes you. Honorable Speaker, what right does the National Assembly have to say that in a joint sitting we will be subject to the rules or the standing orders of the National Assembly? Yet it is a joint sitting. In fact, the fair thing to do, and I'm sure if these rules or these proposals originated from the Senate, we would have special joint sitting rules that accommodate all those, both houses. Honorable Speaker, as you know, I don't attend those joint sessions because they are chaired by Honorable Moses Wetangula. And if Gerard Gay thinks that, maybe the Speaker of the National to him, I can assure you that when it comes to me as Sifuna, I would even receive harsher punishment. I have seen some people, Honorable Speaker, online, proposing that maybe during the debate of the finance bill, I should go there and grab the budget and the bill, the finance bill, and run away with it like happened in some country in Asia. Those people don't know the Speaker of the National Assembly. I would be expelled from Parliament for 5 years without even thinking. So, Honorable Speaker, we want the same rules that we are used to debate on here in the Senate should be applied during joint sessions, because it essentially means that we as members of the Senate have to start learning the rules of the National Assembly, yet we are not members of the National Assembly. Honorable Speaker, and by the way, those rules are not necessarily too different, but there are some small differences here and there. And I'm sure you have seen even here, members struggling with our own rules here. So imagine subjecting some of these members who just shout point of order for nothing to the rules in the National Assembly. So, Honorable Speaker, to protect the slow learners in the House, the people who are still acclimatizing with the standing orders 2 years down the line, Honorable Speaker, you cannot subject these members to the rules in the National Assembly. They will fare far worse than they have been doing for the past 2 years here. And you can see, Honorable Speaker, that when you speak about bonds, the old people start crying, thinking you are talking about them. I thank you, Mr. Speaker. I oppose this bill.
Thank you, Senator Sifuna. Senator Monigi Alex Munye.